I think a lot of people have this misconception that if they hire a lawyer, all their problems go away, right? And you know, I say to my clients a lot, like, you know, sometimes we're involved in triage, and not every time does an emergency room doctor save the patient, right? Like sometimes they just come in too damaged, too wounded. I don't care who you are.
The facts are the facts.
That's right. That's right.
If you're dealt a bad hand at the blackjack table,
Yeah,
it's a bad hand.
That's right. I mean, you can be as skillful as anybody, but yeah, you're sitting there with a 2 and a 6 or something, and it is what it is. So I do think, though, that managing clients' expectations, because I do find that sometimes clients, especially the clients that you've been successful for, they get used to you being successful for them, you know, and it's then they give you a set of facts, which, you know, everybody knows I used to coach a lot. I've retired from coaching, which is awesome. But I think the greatest line of all time is it's not the X's and O's, it's the Jimmies and Joes, right? And I think the idea of that applies to the practice of law, that we're only as good as the facts we're given, and we're only as good as our clients will listen to our advice. Because we can provide as much advice as possible, but if our clients go in 180 degree direction different, I mean, I know you see that a lot in domestic and criminal.
Absolutely. And that's why we have to be able to balance their emotions versus the law, because we can tell them the law says this, and this is what we expect to happen in court, and you need to be doing this in order to avoid there being any issues. But if you ignore your attorney's advice and just act on those emotions anyway, you're gonna make our job a lot harder, and you might end up screwing things up for yourself. So, I mean, it's great to take that step to have a lawyer get involved, but then you have to be able to listen to us. And
your attorney help you.
Yes.
And don't create more issues. Don't show up at your sentencing, and as you're going through the security, put your pound of weed and a gun on the conveyor belt.
Yeah.
That sentencing might not go as well for you as it was going to before that incident.
I think anytime you hire an attorney, you have to realize that, we're here to help you, but you're also a team. I mean, it's not a one-way street. And I think my best clients, my favorite clients, are ones that they ask questions and they say, yeah, but what if this? But then they also, they listen.
I think you have to be honest too with your attorney, because when you're not honest and you try to push things under the rug and then it comes out, you just made our job tenfold harder.
Yeah. A lot of clients that come to us, their goal is to litigate, and sometimes litigation is just not in the picture. And, the mediation is always a really good option. Or sometimes you just, if they're still employed, if it's an employee comes to us and they're still employed, sometimes it's just resolving the issue and getting the employer to step up to the plate and resolve the issue. And people, clients sometimes are disappointed that they're not going to go sue the employer.
Resolution is not weakness.
Yeah.
And resolution is not weakness on the attorney. So I think sometimes society and TV creates this expectation that, my lawyer needs to put on boxing gloves and he needs to literally go into a courtroom and physically beat up the other attorney, and that's going to win me my case. Yeah. But because sometimes of the hand that our clients are dealt, and some of the things that maybe we know that the other side doesn't know yet, resolution is sometimes the absolute most adult thing to do in the room. And I think convincing clients that resolution and other things such as mediation or informal resolution is absolutely in their best interest. And I think sometimes younger attorneys struggle with that a little bit. I know I did as a younger attorney. I think I tried more cases and fought more fights as a younger attorney. And I think you need to get beat down a little bit, and you start realizing when you have a good hand to go to trial with, and when you have a hand that maybe we shouldn't go to trial with this hand.
Yeah,
But you bluff your way that you have a good hand until you resolve it.
Yeah, I think as long as I've been practicing just over 20 years, and there's less emphasis sometimes on settlement or trying to resolve things than there was years ago. Even in judges, it used to be, a circuit judge would haul everybody in a month before trial and say, where are we at? Can we get this settled? There's more of a hands-off approach now. And it's, again, I think sometimes we don't really appreciate the risk. there's no harm. I always would view the ability to give a judge or a mediator, that's somebody else to kind of look under the hood and give you an assessment. You know, the other day when I was mediating a workers' comp case, and they use a judge to do the mediations, and when he said, I believe my recommendation in this case is right here, it was identical to what I had thought. You know, you feel good as an attorney, and it helped your clients see that, hey, you were probably right, that judge thought that's where the case needs to be at as well. And then when the other side didn't want to get there, it was really easy to walk away because, you know, it was me and that judge saying that's probably where the case needs to be at.
But in that same breath, I think you need to try enough cases each year that you do know where value is on cases, right? Because I think there's shifting sands of value in communities. Post-COVID, I think we saw some normally conservative jurisdictions give some very large judgments. I mean, frankly, our office was the beneficiary of a very large post-COVID judgment in a normally conservative jurisdiction. So I do think that one thing that helps us as an office is because we do so much litigation on both sides, and that we're big enough that we're still, as an office, probably trying 5 to 8 cases a year. So even though 95% of our files are resolving, by trying 5 to 8 cases a year, we have a pulse and a sense for where value is.
Well, and you've got to, you know, no matter what, the facts are the facts. And what always scares me is when you have a client that is afraid to say something, because it's going to come out at a trial. My view is I'd rather know the good, the bad, the ugly, because then we can get ahead of it. Because I still, most of the time, I think some of these recent verdicts, you know, I've had retired judges say, well, that plaintiff was a quote-unquote salt of the earth type person. At the end of the day, I still think juries look at him and they're like, this person seemed truthful, nice, you know. They seem to appear to be telling the truth that, you know what, that employer looked pretty bad. They didn't seem to really care about that person. You know, that's what people apply. And so no matter what, you know, the facts, the truth, that's what you got to focus. Your clients need to tell us all that because, you know, that's the biggest thing. I mean, jurors, I think they're evaluating the testimony about 50%, and they're looking at mannerisms of your client and all that. You know, that person who sits at a trial, and if something said it upsets them, you know, throws their head back in disbelief and all, jury's looking right at them, and it makes them uncomfortable. And I think that works bad against them. I also think, contrary to what you see on TV, jurors do not like to see the lawyers fight. I think that the first employment case I ever tried, I actually lost, and the jurors called and said I did a great job. But the one thing they liked was that the other attorney and I did not fight. They're sitting there; they don't want to have to feel like they're refereeing two lawyers acting like jerks to each other. You know, put your case on, but be civil, be respectful to opposing counsel, the judge, the jury, and I think that goes to the whole theme that you take the high road in litigation, and usually you win.